I would like to welcome you to the American Constitution Society's annual Supreme Court preview. I'm Caroline Fredrickson, the president of the American Constitution Society. As many of you may know, and hopefully all of you already know, ACS was founded in 2001 and is a national network of lawyers, law students, judges, and policymakers who believe that the law should be a force to improve the lives of all people. ACS works for positive change by shaping the debate on vitally important legal and constitutional issues, such as the ones we will discuss today. So it seems that every June I stand up here and I remark on the blockbuster quality of the Supreme Court term that has just ended. This year is, of course, no exception. From the challenge to the Affordable Care Act to the continued viability of the disparate impact standard in discrimination suits to marriage equality, more could not have been at stake for millions of Americans. And as we head into the 2016 presidential election, no one needs reminding about the importance of the courts and who is nominated to sit on them. So to get us started in the examination of the October 2014 term, let me introduce our moderator, someone who is no doubt already extremely well known in this room. Tom Goldstein is an appellate advocate. He is known as one of the nation's most experienced Supreme Court practitioners. He has served as counsel to the petitioner or the respondent in roughly 10% of all the court's merits cases for the past 15 years. Personally arguing 35. In addition to practicing law, Tom has taught Supreme Court litigation at Harvard Law School since 2004 and previously taught the same subject at Stanford for nearly a decade. Tom is also the co-founder and publisher of SCOTUSblog, which is still the only weblog ever to receive the Peabody Award, or as Jerry Hebert would say, the Peabody Award. You'll hear about that later. Anyway, in 2010, the National Law Journal named him one of 40 most influential lawyers of the decade, and the Legal Times named him one of the 90 greatest Washington lawyers of the last 30 years, and praised him for transforming the practice of law before the Supreme Court. So who could be better than Tom to navigate this term for us? So please join me in welcoming Tom Goldstein.
So thank you all so much. On behalf of the panelists, I really do appreciate that you all have taken the time to come and be with us to talk about the Supreme Court term that just concluded. It is an extraordinary thing. We've been doing this for roughly 10 years or so, and this is the first time that it will be more fun than the Federalist Society wrap-up. It was an incredible term. I have learned a great deal about it. I have learned that I am now required to get same-sex married, that both my partner and I will receive subsidized health care and everything else, which we will need because the court has now required industries to put more mercury into the air. So to fill in the details of that, we do have an extraordinary group of people, subject matter experts, folks who know a ton about the Supreme Court. I'm personally very, very excited to hear what they have to say. And we have one particular approach, and that is we think that you all are a self-selected group of people who know what's going on at the Supreme Court. And particularly with respect to the biggest cases, we're not here to tell you what happened. We're here to analyze. We're here to tell you what's going to happen in the future so that you can have a broader and deeper appreciation of what it is that the court has done and what it is that you can expect to see in coming years. There are two dominant cases, but lots and lots of important ones, as Carolyn says. And so let's start with same-sex marriage. And we could not be more fortunate to have someone than Bill Eskridge, who is a professor at Yale, but more than that, is perhaps the nation's foremost scholar and authority on questions related to gender and sexual minorities. And can you talk to us about the same-sex marriage ruling?
Yeah, why don't we get started with Justice Kennedy for the majority makes a choice. It's very striking that the majority decision rests upon fundamental rights, fundamental right to marry, and not on the denial of equal protection that Kennedy's earlier decisions in Romer and Evans, and to some extent Windsor, relied on. So he goes with the Griswold and specifically the Lawrence versus Texas mode of analysis. Now, why do I think Justice Kennedy did this, and what are some of the consequences? Well, to begin with, I read Obergefell as a wedding of Anthony Kennedy's personal enthusiasms, the European focus on dignity, a word that recurs in this opinion and elsewhere, and apparently his very deep admiration for marriage, which is described in the opinion as transcendent, sacred, the foundation of family, foundation of society, foundation of government, without which, I'm quoting, there would be neither civilization nor progress. Wow, says Sigmund Freud. Justice Kennedy further says marriage is a unique form of commitment, quote, responding to the universal fear that a lonely person might call out only to find no one there. Words that I'm sure still haunt the three women in the majority, none of whom is married. Now, as Justice Thomas points out in his dissent, liberty has traditionally been understood as freedom from government interference. And Thomas points out that even Zablocki, the deadbeat dad's case, and Loving, the anti-miscegenation case, had that feature, government oppression. And Justice Thomas reminds us that marriage is actually a highly regulatory institution with lots of restrictions as well as lots of benefits. So Kennedy is using liberty apparently in a much broader sense, certainly than the original framers, as Thomas points out, but in a sense of the freedom to construct life choices within a government framework similar to everybody else. And that's where Kennedy brings in equality as part of the calculus. That's the first thing. Second thing, here is another advantage of Justice Kennedy's, from his point of view, choice of fundamental rights. If you go with heightened scrutiny, and this is some kind of heightened scrutiny, though not very well specified, it enables the majority to avoid any discussion of animus, a word that was prominent in Romer and Evans and mentioned also to some extent in Windsor. Kennedy, in fact, goes out of his way to be respectful of adherence to traditional marriage. And he recognizes, I think implicitly but clearly, that the traditional marriage folks are frightened to death that they're going to be associated with bigotry, and their grandchildren will see them as the George Wallaces of their generation. Now, this doesn't satisfy the dissenters. Justice Alito, in particular, worries that traditional marriage adherents will be, to use his word, vilified. But I don't think it's so much because of Justice Kennedy's reason. Just as Thomas correctly points out that the government doesn't confer dignity, I think the government does not do a very good job of conferring vilification. Here's a third reason why I think Kennedy went with fundamental rights rather than a straight, quote-unquote, equal protection clause analysis. And that is that an equal protection clause analysis might have brought sexual orientation out of the closet as a quasi or suspect classification, either explicitly or by implication. And Kennedy, I think, wants to keep the court's options open to respect religious and traditional marriage, libertarian rights to exclude or to discriminate. Because remember, Justice Kennedy was a fifth vote in both the Hobby Lobby case last term and years ago in the Dale and Boy Scouts case. And Justice Kennedy, I think, is loath to close off those options. Now, that's where I think he's coming from. You notice I didn't say that's where Ginsburg et al. Are coming from. This is kind of an implicit deal that if Justice Kennedy's going to deliver the fifth vote, then you sort of go with the bride who brought you. Now, there are some disadvantages to a fundamental rights analysis, highlighted by the near hysterical dissenting opinions in this case. So, for example, substantive due process, which much of this sounds like, and fundamental rights, which this is much more controversial because unlike the Equal Protection Clause, it's not clearly rooted in the Constitution's text, marriage is never mentioned, or even original meaning. There's a lot of rich original meaning evidence in the Equal Protection Clause, as I argued in my Cato brief, that would support the same ruling here. The four dissenters, therefore, go to town. Chief Justice Roberts raises and celebrates the ghost of Lochner Judicial putsch is the way Scalia decides this. This is what the majority is engaged in. But I must say in defense of Kennedy that Kennedy does say if you take the right to marry precedents seriously, they are part of the rule of law in America, and you apply them, it's very hard to deny this to lesbian and gay people. 25 years ago, I relied mainly on Turner v. Safely, which is relied on in the majority opinion as well, 1987 decision, where Missouri allowed procreating prison inmates to marry, but not other inmates. Supreme Court unanimously struck that down, no dissent, an O'Connor opinion. And it seems to me based upon the idea of committed relationships as the basis and the benefits basis of marriage. And I've always thought since 1987, how can a civilized society give convicted murderers and rapists a fundamental right to marry, but not give it to committed lesbian couples raising children, like DeBoer and Rouse in the Obergefell case? A second problem is that the famous redefinition argument has more bite against the fundamental right to marry than, say, against an equal protection clause analysis. This was the Chief Justice's big concern at oral argument. Chief Justice said, erroneously, I might add, marriage has always been different sex. That is simply false, canard, untrue. It is not disputed, but it's untrue. But then he makes the better point that fundamental rights marriage, says the Chief, has always assumed a different sex, from Maynard to Loving to Turner. True. And then the Chief says, for us, the Supreme Court, under the aegis of fundamental rights, to redefine marriage in this way is a really big move and not something the court often does. Chief Justice says, quote, just who do we think we are? Now, I think the right answer to the redefinition argument is that Michigan, Ohio, et al. Have already redefined marriage in their positive laws, away from the imperative of procreation and toward committed relationships and a structure for those to flourish. And everybody gets this in the state of Michigan and Ohio, except lesbian and gay couples raising children. And so it seems to me that's the answer to the redefinition question, though not a path that Justice Kennedy follows. Third problem with fundamental rights analysis. The leading case is arguably Glucksberg. That was the 97 right to assisted suicide or aid in dying assistance. Rehnquist's opinion, which Kennedy joined in full, defines the fundamental rights analysis very narrowly and very historically. The Kennedy opinion, interestingly, associates Glucksberg, which he joined, with Bowers, and jettisons the specific historical tradition approach by using the marriage precedents in a very effective way. This predictably drives the dissenters crazy. They argue, with some sense, if justices can set the level of generality anywhere, then they are free to expand fundamental rights jurisprudence. What are the limits? Is this not anti-democratic? To which Kennedy's response is kind of, democratic deliberation has been exhausted in this case. It was just beginning in Glucksberg on the aid in dying issue. And you can just see the arguments that are now used. The irresponsible procreation argument is an argument of an exhausted discourse to exclude lesbian and gay couples. And so the way Kennedy sees it, his opinion is basically a cleanup operation. The democratic process has worked. It's not going to work very well in Mississippi and Arkansas and some of the other states that were still outstanding. And therefore, it is meet, as the Supreme Court did in Loving versus Virginia, similar number of states, to clean it up. Moving forward. What do I see moving forward? I see a lot of things until I get yanked time-wise. So, one thing. I do think the big take-home point for Obergefell is how broadly are we going to understand the liberty jurisprudence under the Due Process Clause? And I would read the majority similar to the way I would read Lawrence and Casey, which I think is unmentioned in this case. And that is, the government exists. This is a post-Hobbesian understanding of government. So, but see Clarence Thomas. Government exists to create a structure for Americans to make life choices which allow them to flourish. This is libertarian, at least the way Anthony Kennedy and Bill Eskridge understand it. And then further, and this is where Kennedy ties in the equal protection idea, that structure cannot be arbitrarily denied to minorities. And here, importantly, he would include religious minorities as well as sexual and gender minorities, religious minorities going forward. Can this be relevant, and this is a question, to the abortion choice issues that are going to be confronting the court, such as state laws that have sought to and successfully have closed down abortion clinics? Cannot this regulatory understanding of liberty also apply in those cases, as well as in immigration cases? As we saw 30 years ago, 35, in Plyler and Doe, where children of undocumented immigrants were excluded from the Texas school system, and that was struck down. So that's the first take-home point going forward. Second, going forward, what about the rights of religious and traditional marriage persons? Anthony Kennedy, as I said, voted to protect these rights in some constitutional cases, such as Dale, the Boy Scouts case, and Hosanna Tabor, which is the free exercise and Title VII case. I would emphasize, however, that moving forward for religious minorities and traditional marriage people, their protections are probably more often going to be statutory. V-Day, RFRA, and the RFRAs at the state level, and not unimportantly, Title VII as well, which provides protections possibly for marriage license clerks. Quoting Justice Kennedy, and this is language that will influence later cases, to what extent I do not know, quoting him. Justice Kennedy says near the end of the opinion, "The First Amendment ensures that religious organizations and persons are given proper protection as they seek to teach the principles that are so fulfilling and so central to their lives and faiths, and to their own deep aspiration to continue the family structure that they have long revered." Now, all I would add to that is that in the wake of Obergefell and in the wake of more gay marriages, religion, as I've been saying for decades, has already changed and will continue to change. And mainly not because of government action. It won't be mainly because of Obergefell. It will be because of young people and shifting cultural mores. But keep that in mind. Religion moving from hostility to lesbian and gay marriage to either neutrality or don't ask, don't tell, or sometimes even doctrinal support, as my church, Presbyterian Church, has recently done. Finally, I can't help but say this was a bad day, Obergefell, for the hard right judicial conservatives. Roberts and Scalia, in their dissent, I don't think consciously, the dissent reads exactly like the Harvard Law School's attack on Brown versus Board of Education in the 50s. And then throw in Herbert Wexler, who was a Harvard ally, though he taught at Columbia. That if you substituted Brown for Obergefell, you could simply lift a lot of the Chief Justice's rhetoric, including his fulsome reliance on Oliver Wendell Holmes, who was, it's true, a critic of Lochner, which the Chief Justice raises like a bloody flag. But Holmes was also, don't forget, the author of Buck versus Bell, the notorious sterilization decision, where Justice Holmes not only upheld a scurrilous denial of liberty, but then added insult to injury, 3 generations of imbeciles is enough, right? One of the most infamous sentences in a judicial opinion, almost matched in Justice Scalia's dissent, particularly footnote 22, where he wants to hang his head in a bag, and where he ridicules the majority opinion as engaged in mystical aphorisms of a fortune cookie. I think original meaning jurisprudence did very badly on Obergefell's day, and I'll conclude with what's the future for the LGBT rights movement. I think we're going to see the LGBT rights movement move very rapidly from courts to legislators, and operative officials, from judges to administrators. We've already seen that to a significant effect. The focus has got to be anti-discrimination laws, educational programs, healthcare needs, and a structuring mechanism, not just marriage, for family choices. Now, one not so good lining for the decision is that moving forward, there will be overwhelming pressure for good and bad reasons in anti-discrimination laws to include conscience allowances, probably broader today than would have been felt appropriate 3 years ago. Thank you. under time?
Couldn't be more perfect. That is fantastic. The second really kind of major case from the end of the term is, of course, the subsidies challenge to the Affordable Care Act. And to talk about that, we have Jeff Wall. Jeff is the co-head of the appellate practice at Sullivan and Cromwell, which is obviously an incredibly prominent international law firm. He previously served in the Solicitor General's office. He's argued 10 cases himself. He's been involved in literally hundreds of others. So Jeff, can you talk about that case for us?
Sure. Thanks, Tom, and thanks to the ACS for hosting me. So it's always nice to be the bearer of glad tidings, and I think in this crowd it's good news that the court sided with the administration in King v. Burwell. And I think when you say it's a major case, it stood to be if the court had gone the other way. But I think having affirmed the administration's position probably took a lot of the air out of the debate over the case. But there are a handful of things that I think the opinion might matter for going forward. And so talk briefly about those, and then a little bit about the pending challenges, the other pending challenges to the Affordable Care Act and what this might mean for those cases. I mean, I think the one really doctrinally significant thing in the opinion is that the court starts by saying, the Chief Justice says, look, this is just too important to apply Chevron. If the Congress had wanted, remember this was an IRS rule that was at issue, and so you would normally think that it would get Chevron treatment, at least that analysis, however you resolved it under the two-step Chevron structure. And the Chief Justice says, look, if Congress had wanted the IRS to decide this, surely it would have said so. I think that's a sort of important clarification. In other cases where the court had invoked this too important for Chevron principle, cases like Brown and Williamson over tobacco or MCI or the utility air case last term, it had always seemed like it was part of the Chevron Step 1 analysis. It was part of what the court was using to find that a statute was not ambiguous, and hence there was no gap for an agency to fill. And here, that's not what the court says. Before it even gets to the two-step analysis and looks at whether the statute is ambiguous, it just says this is too important to even do the normal Chevron analysis. Now, I don't know how much there is to recommend that approach. I'm not sure what it is that makes a policy question so significant that it shouldn't get the normal Chevron treatment. I think this case certainly qualifies. It's just not clear what else comes underneath the umbrella. And I'm not sure why the court is so sure that Congress wouldn't have wanted the IRS to decide it. We know now that the mandate imposes a tax. This case was about tax credits for individuals on a federal subsidy. And if the administration was right on the merits, that Congress would never have contemplated that these individuals on federal exchanges could not get the tax credit under the Act, then you would have thought that there wouldn't be that much controversy over the IRS saying so in the face of any ambiguity on that score. So I have some doubts about whether this too important for Chevron doctrine is capable of principled application going forward. I also am not as sure as some folks that it will matter all that much. I mean, by and large, the court is invoking it in cases where most of us are probably more comfortable with the justices making these decisions than agency administrators. Certainly, I think that's probably been the intuition in this case. And I also think, and Bill can correct me if I'm wrong, that having upheld the Affordable Care Act, I suspect there will not be an outcry in the Academy over whether the court was being faithful to Chevron. I think, at the end of the day, the only thing I will say is that, some folks have lauded the Chief Justice's opinion as one of judicial modesty. I'm less sure about that, because whatever you think about the notion that some questions are just so important that they have to be decided by we, the justices, I don't think that's a conception of the judicial role that could be fairly described as modest. And I think the folks that are lauding, I think when folks laud this opinion as one of judicial modesty, I think what they're really saying is that on the merits, they agree with the court's statutory analysis, and they think that the court should not have disrupted the current way that the Affordable Care Act functions. I don't think it's really a claim about the role of judges. On the merits, Look, I think my own view is that there was a disconnect between the case and a lot of the commentary over the case. I think there were a lot of people who said and wrote that this was an easy case. I'll be curious to see what the other panelists think. My own view is that it was a harder case than people give it credit for. I think if you believe in text or purpose, come hell or high water, it's an easier case. But for the moderate justices, they are reluctant to ignore text in order to look at larger claims of purpose, just as they are reluctant to read words in ways that they think would accomplish ends that Congress did not intend in the statute itself. And I think Bill and others made some very clever and good arguments about why this was not a case about text versus purpose. It was a case about good textualism and bad textualism and all the rest. But I do think that, bubbling up for the Chief Justice, and I suspect for Justice Kennedy, whatever the force of those arguments, there did seem to be a real pull between what the statute seemed to say on its face and what we all seem to believe that Congress was intending, notwithstanding what may have been some inartful drafting in the provision. As you know, the majority said, look, if exchange established by the state means just that, only state exchanges and not the federal exchange, both in the provision directly at issue in the case and in other related provisions of the Affordable Care Act, it would really, it seems, put the statute at odds with itself, because none of the individuals on the federal exchange would qualify for subsidies. But the Act clearly contemplates in a number of provisions that individuals on all of the exchanges, whether state or federal, are eligible individuals and can get the tax subsidies. And that's enough, the majority says, to make it ambiguous. And then it turns to resolving that ambiguity. It says, by looking at the structure of the Act. I think when you boil down what the court says is context and structure, I think it amounts to a set of arguments that are really about purpose and consequences. I mean, as the Chief Justice says in his opinion, this act was passed to improve health insurance markets, not destroy them. And I think it really turned on the fact that the Chief Justice and Justice Kennedy and the more liberal members of the court did not think that the challengers to the act had a very compelling story to tell about why exchanges established by the state would mean only state exchanges. You can tell a story about why they would have wanted to induce states to create their own exchanges, but there certainly was not ample evidence of that in the legislative record of the act, and though the court didn't say it, it almost felt like a dog that didn't bark case. If that were really the way that the act had been structured and what they were attempting to accomplish, you got the feeling you would have seen more evidence of it than some after the fact comments by folks who were who played some role in the legislation. So I think at the end of the day, it really did turn more on a story about purpose than it did about some of these textualist arguments. And I think the administration had a more compelling story to tell about why its interpretation must have been the one that Congress had intended. And you get flavors of that in the Chief Justice's opinion when he says, look, there's a lot of inartful drafting throughout this statute. Now the dissent says, look, we change all the rules again and again in order to uphold the Affordable Care Act. And is that a fair criticism? I think in part it is and in part it isn't. I'm not sure that it is, I'm not sure the dissent's right to say that the court had to strain to create ambiguity here any more than it does in a range of cases that get far less attention. Is it more of a strain to find ambiguity here than it is to say, as the court did in Yates, that a fish is not a tangible object that can be destroyed or concealed? I'm skeptical. I had always thought fish were tangible objects. I mean, and so other than the intensity of the spotlight, I'm not sure that the court had to work a lot harder here to find ambiguity than in any number of cases where it resolves hard statutory questions. I do think it is fair to say that whether or not the Chief Justice or Justice Kennedy thought this was really ambiguous, they did seem to think it was a drafting error. And I do think it is fair to say that in other contexts, the court has been much less hospitable to that argument. I mean, Tom has gotten questions before, indeed from the Chief Justice, so am I, about, look, I'm not worried about how we come out because maybe it is a mistake, but Congress can fix it. And that argument seems to have a lot more sway in other contexts than it had here. I think because in most contexts, it's a pretty benign and useful legal fiction. Here, it would have seemed ridiculous because everyone knows that the last thing Congress would have done is amend this provision to add established by the state or the secretary in lieu of the state. And so I suspect that they felt not being able to write that opinion, they really had to put it on ambiguity and then resolve that ambiguity by purpose. What does it mean going forward? I mean, I think the act is here to stay. There'll be some legislative attention to various things like the excise tax on high-end plans and some of the reporting requirements. There are still some pending judicial challenges. There's the origination clause challenge, which the DC Circuit has rejected. I think there's an en banc petition pending. I don't see anything here that I think would increase the chances of en banc or cert. And then there's two more cases pending in the district court in DC. One to an appropriation that the White House has made to some of these health insurance companies of about $175 billion, claiming that that's not authorized by the act. I think that case actually, the House, that's brought by the House of Representatives against the Secretary, I think that case got a bit of a boost from the Arizona decision. There were standing questions about whether the House can bring that suit. Granted, it's only the House, it's not the entire Congress, but the Arizona case allowed for standing there, and surely enough, the House sent a letter to Judge Collier yesterday saying we think the Arizona decision helps us on the standing piece of it. I don't see much here on the merits that would affect it, but it may make it more likely that Judge Collier has to reach the merits. And then there's the case brought by West Virginia, also in the DDC, that's been reassigned to Judge Maida on the administrative fix regarding individual plans. Doctrinally, I don't know that this case helps the Secretary. The Chevron discussion actually may hurt the administration a little, but I think there's no denying that atmospherically there is very much a feel now that the challengers have gotten their day in court, and it's hard to think that that won't influence some of these pending cases.
Thanks so much, Jeff. We'll now turn to really what are three big buckets of cases, bodies of law that the court confronted in a number of decisions. The first of those is going to be the First Amendment, and we have the great good fortune of having Nadine Strossen, who is known to all of you. She's a professor at NYU, but is really one of the nation's foremost experts, recognized as such, on really almost any civil liberties question. For many years, she was the director of the ACLU. So can you talk to us about the First Amendment?
I certainly can, but I'm going to start by censoring one word in your fine introduction, Tom. It's not NYU, it's New York Law School. And I have a couple student research assistants here from New York Law School whom I would like to thank for their support of ACS and me, Chloe Caniaris and Josephine Bond. I am delighted to be here at ACS, which I've been an enthusiastic supporter of from the very beginning. And I'm thrilled at how this organization is doing. I have to say, I also am a frequent speaker and debater before another organization that Tom mentioned in his introduction. And every time I have the opportunity of speaking to that group, I thank them for what I consider their single greatest achievement, which is spurring the foundation of the American Constitution Society. So, coincidentally, the last time I had the great good fortune to speak before this group at an annual convention a couple years ago was also on the Roberts Court and free speech decisions. And I stressed a point that still is not nearly as well known as it should be, namely that the Roberts Court overall has a very mixed record on freedom of speech. And that's surprising to many people because so many of the court's marquee free speech cases, the big name media heavily covered cases, the court has indeed protected, controversial, and unpopular speech. But its overall record is very mixed, and the current term illustrates that. There were two major free speech cases. One of them upheld free speech rights in a way that expanded an important speech protective theory. The second one contracted, rejected free speech rights, and doing so in a way that that expanded a speech suppressive theory. So both of these cases will have big ongoing implications. The first case was Reed versus Town of Gilbert, which was a case that struck down a town's sign regulation ordinance that drew distinctions on the basis of the content of the signs. And the court reached that result, importantly, by expanding the concept of content-based speech, its definition of content-based speech regulations that will therefore automatically trigger strict scrutiny, therefore almost automatically condemning to unconstitutionality the regulation. And it did so by undermining past rulings that had a narrower concept of content-based regulations and therefore allowed unpopular, controversial speech to be suppressed. The second case, in contrast, Walker versus Sons of Confederate Veterans, upheld state power to deny the selection of messages by private speakers on specialty license plates. Worse yet, did so under a criterion, I'm going to read it here, if the design might be offensive to any member of the public. How is the court able to allow what we would generally think of as the most blatant viewpoint discrimination, completely contrary to core First Amendment principles? It did so by describing this expression as government speech, a relatively recent category that is completely exempt from any constitutional free speech protection at all. This is definitely an expansion of that government speech sanctuary from First Amendment protection. So we've got these two contradictory rulings, really. On the one hand, Reed contracting the government's ability to discriminate on the basis of content and viewpoint, but Walker doing exactly the opposite. That's the bottom line. From now on, until my gong goes off, I'm going to amplify a bit on each of these cases, starting with the Walker specialty license plate case, the bad news for free speech. In terms of how far that case was a retrenchment on existing free speech protections, I want to stress that we had 8 circuit courts of appeals had ruled on this issue, and a full 7 of them sustained the free speech right. So the Supreme Court was really bringing us in a backwards direction. Now, here I want to quote my friend and the great First Amendment advocate, Bob Korn-Revere, who is in the audience somewhere in this direction. Bob said, and he gave me permission to quote this, "The Walker opinion began with the 8 scariest words in First Amendment law, quote, Justice Breyer delivered the opinion of the court." To be true, to be sure, Justice Breyer is generally less speech protective than other justices because he eschews categorical rules and tests which tend to be speech protective. For example, in Reed, he reiterated his unique view that content-based speech regulations should not automatically trigger strict scrutiny. In Walker, ironically, Justice Breyer's majority opinion did base itself specifically on a formal categorical rule, namely that once speech is categorized as government expression, it is completely exempt from the First Amendment, period. Now, to heighten the irony, the last time the court discussed the government speech exception, and as they've called it, the newly minted government speech exception from First Amendment protection, was 2009 in a case called Summum, And in that case, Justice Breyer had disavowed precisely this categorical approach to government speech, which he then supports ironically, in the Walker case. In summum, in 2009, Justice Breyer concurred, quote, on the understanding that the government speech doctrine, and he even puts that in quotes to indicate that he doesn't think it's a fixed doctrine, is a rule of thumb, not a rigid category. Even more pointedly, in his concurrence in summum, he says, if the government discriminated in its selection of private messages on political grounds, its action might well violate the First Amendment. I say this is ironic because in Walker, the government did discriminate on political grounds in deciding that it would not grant a specialty license plate to one message, but it would to another on the very same day, no less. And this is a factual aspect of this case that is mentioned in Justice Alito's dissent, but to my surprise has gotten very little national media attention at all. Of course, it's well known that the Texas Department of Motor Vehicles, DMV board in question denied the particular license plate at issue in the case, namely one that featured the embattled, so to speak, Confederate battle flag. But what is much less well known, oh, and let me say that the reason that was given was that many members of the public find the design offensive. Of course, offensive speech, as we know, is constitutionally protected if it's private speech in a public forum. What's much less well known is that on the very same day, the very same board, despite testimony from many other members of the public that the design was offensive, did agree to issue a specialty license plate celebrating the Buffalo Soldiers. The Buffalo Soldiers, as many of you know, are an all-black cavalry unit that fought in the Indian Wars in the late 19th century. Many Native Americans said, and who testified before the DMV, they felt the same way about the Buffalo Soldiers as African Americans felt about the Confederate flag. One Native American leader said, when we see the U.S. cavalry uniform, we are forced to relive an American Holocaust. So now, thanks to this decision, government has carte blanche to pick and choose, not only between certain battle signs and uniforms, between certain minority groups who are offended and others who are offended, but also between any other controversial messages, including pro-life and pro-choice, which in fact have been selectively denied and approved in various states. Now, to be sure, if it is the government itself that is in fact speaking, of course, as a practical matter, the government may pick and choose its messages, accountable not under the First Amendment, but only to the electorate. But the problem is, in a case like this, the government is selectively endorsing and disfavoring private speakers and private messages, which the Supreme Court has repeatedly said violates the bedrock principle of the First Amendment, that government may never censor expression just because the majority of the community, even the overwhelming majority of the community, finds the message offensive. And in summum himself, the Supreme Court said, the government speech doctrine must not be used, I'm quoting, as a subterfuge for favoring certain private speakers over others based on viewpoint. So Walker seems to be inconsistent with summum. There's no better expert to make that point than Justice Alito, who, number one, wrote the majority opinion in summum and writes the dissenting opinion for 4 justices in Walker. So there's special force to his critique in Walker when he says the majority badly misunderstands summum. He gives many examples to illustrate one key point, which is that no reasonable observer is going to look at these hundreds of specialty license plates that Texas issues as conveying a government message. One example he gives is if you're driving at 8:30 on a Monday morning and you see a car with a plate that says, rather be golfing, would you think, this is the official policy of the state, better to golf than to work? So that brings us to the good news on the First Amendment.
Can I just
Yes,
interrupt? I want to make sure that we get through all the topics, and so hopefully we can come back and talk about
Okay.
the good news in the First Amendment.
Okay.
Terrific, thank you. There were a number of really significant criminal law, criminal justice cases this term. The person who's going to take us through that is Cynthia Jones. She is a professor at the Washington College of Law. She's the co-director of the Criminal Justice Practice and Policy Institute. She was my instructor in law school. She gave me my first grade, which was an F. And so I would like to air some grievances afterwards. And so will you talk to us about the criminal law docket?
Thank you. Back when you were my student, you were known as Tommy. So if you keep bringing up that F, I'll start calling you Tommy again. So the Supreme Court in 3 cases that I'm going to talk about really expand the space between the ability of the state to administer criminal laws and the constitutional protection afforded to people who are accused. In Glossop versus Gross, the Supreme Court tackles an 8th Amendment challenge to an Oklahoma statute dealing with the lethal injection drug. And in Ohio versus Clark, the court tackles the issue of whether the 6th Amendment Confrontation Clause protects a defendant from a statement given by a child complaining of abuse when that child doesn't testify at trial. And in Hine versus North Carolina, the Supreme Court deals with a scenario, you would think improbable, but not very improbable, where the police officer arrests someone. They stop a car in a traffic stop, and the basis for the stop is actually conduct that's not illegal. So they stop the car saying, you should have 2 working brake lights, when actually under the law, you're not required. Is that an unreasonable seizure if in fact your conduct didn't violate the law and there was no legal basis for the stop? The defendants lose in all 3 of those cases. And I think that each case sets very important precedent and gives us somewhat of a roadmap where things are going in these 3 areas. Starting first with Glossop, there's no way I can, in 12 minutes, fully cover the scope of this opinion, but I'm going to try to do it justice and move on to the other 2. In Glossop, the court took on what appeared to be a strategy of death penalty abolitionists, and that was, if we keep eliminating or making unavailable the drugs needed for the lethal injection cocktail, states will not be able to administer the death penalty because they won't be able to get the drugs. We'll work with the manufacturer. We'll make sure that people who are shipping it in from overseas, we will attack their ability to get the drug that they need. The strategy appeared to be working, and they had successfully eliminated 2 of the cocktails needed in this 3-drug cocktail. So let's just be clear. 3 drugs are needed. The first drug is the drug that basically puts the person in a coma, or it makes it so that they can no longer feel pain. At least that's what it's supposed to do. The second drug causes paralysis, which would be painful if you didn't have the first drug. And the third drug induces cardiac arrest. And so that sequence of events is how they administer the death penalty. And the first drug is the drug under attack. The death penalty abolitionists and the death row inmates said, this drug does not, in fact, cause this sense of painlessness and put the person in a state where they cannot feel the pain of the paralysis and of the cardiac arrest. It doesn't work. And the Supreme Court said, and they took great pains to note, you eliminated the other drugs that were working, almost as if to say, you'll not be heard to complain. They don't go that far, but they take great pains to say, there were 2 other drugs on the market that were being used, and you effectively got rid of those drugs. And the court says, in order to mount an effective 8th Amendment challenge to this lethal injection cocktail, you not only have the burden, condemned prisoners from Oklahoma, you not only have the burden of showing that the drug being used actually does needlessly inflict severe pain, you also have to show that there is no other reasonable and available alternative that would be less painful and less cruel. And the court articulates that second prong as if it's always been the law. The dissent takes them to task, saying that has not been the burden placed in Eighth Amendment challenges, and the majority, it is now. The majority makes very clear that if you are challenging this, you have to show both things. And the court says neither of those were met that would justify an injunction. You didn't show that the drug as administered did not cause the condemned person to experience no pain prior to the other two parts of the cocktail. And even if they did, the court said, even if you managed to show that, you have to prove, in order to prevail, that there was no other available drug, that there is an available other drug on the market, that there is another drug that could have been used and that they're not using. And effectively what that does is it makes the Eighth Amendment almost completely out of reach. If this is your strategy for challenging the death penalty, in order to prevail, that burden makes it extremely difficult for abolitionists and condemned prisoners to prevail, that you'd have to show that there was this alternative. So in Glossop, the court notably says, there's going to be some pain involved in administering the death penalty. That's not what the Eighth Amendment prohibits. It's this needless suffering and torture that is prohibited. I think in the end, Glossop will be known more because of the dissent than it is because of the majority. Because in the dissent, shock of shocks, two justices state pretty definitively, Breyer writes the opinion, the dissenting opinion, and Ginsburg agrees with this opinion, that it's now time to examine whether the death penalty is constitutional. Pretty definitively, they go on to say, we believe it is not. Causes Scalia to almost explode. Just about explode. The debate now going on, and I think it will invite litigation, it will invite other challenges to the death penalty. Abolitionists know they have a couple of votes, perhaps more votes on the Supreme Court now. And I think that this case will be known for two justices coming out and saying, I believe at this point, I'm no longer tinkering with whether this part of the death penalty works or whether we can fix it with this patch. I believe at this point it is a violation of the Eighth Amendment because it's cruel and unusual punishment. So I suspect that going forward we will see lots more cases involving that. On to the second case, Ohio versus Clark. Ohio versus Clark deals with something that Scalia holds very near and dear. He rewrote the law on the confrontation clause. He basically gave defendants the right to confront any person who's making a testimonial statement against them out of court. So the scenario that exists is an individual here, a child, goes to the teacher and says, I was physically abused by my mother's boyfriend. The child does not testify at trial. The teacher testifies, and the defendant says, I have a right to cross-examine or confront that child. And the Supreme Court says no. If the statement that was made out of court that you don't get to confront at trial was testimonial in nature, that is, at the time that statement was made, it was pretty clear that that statement was going to be used in a criminal prosecution, then you have the right to confront that statement. That is, the government will not be able to use that statement against you at trial unless the child testifies, provided you didn't have a prior opportunity to cross-examine the child. The defendant says, this is the scenario when the teacher basically went to the child and said, who did this to you? What happened to you? They were conducting the kind of investigation pursuant to a mandatory reporting statute in Ohio. And the Supreme Court said that does not convert the statement into a testimonial statement. There was an ongoing emergency. And that becomes significant because in a series of cases since about 2011, the court has begun to erode away the protections that Scalia provided under the Confrontation Clause in Crawford and the cases in the immediate aftermath of Crawford. And the court has expanded this ongoing emergency exception. So before an ongoing emergency occurred when, the person calls 911 and says, help, help, my boyfriend's beating me up, get somebody over here. And the court says, at the time that statement was made, no one was thinking about prosecuting the boyfriend, you're thinking about getting help for the girlfriend, right? The courts then later said it's an ongoing emergency because even though this child wasn't in imminent danger of being abused at the time, the teachers had an obligation to try to resolve and protect the child and that kind of thing. And so therefore, the ongoing emergency existed in a much broader context and for a longer time. And I think you're going to see more cases where the court is declining to recognize a confrontation clause right and expanding what constitutes an ongoing emergency, exempting the defendant from the protection of the confrontation clause. And the final case is the Hine versus North Carolina case. And here, the Supreme Court does an effective job of insulating police officers who do not know the law. This is a police officer who says, I didn't know that what happened was actually legal. And the court says, as long as the officer was reasonable in not knowing the law, and it was a reasonable misinterpretation of the law, then it doesn't violate the Fourth Amendment. And this case falls in line to a certain extent with cases by the Supreme Court that simply distinguish between whether you have constitutional protection and whether the state can administer the laws the way they decide. And so in this case, the Supreme Court's already decided that a police officer can rely on a mistake of fact. That is, it's not an unreasonable seizure if the police officer says, I arrested you or I stopped you because you matched the description. It turns out you were not the guy who committed the robbery, but you looked like the guy. It's like, it was a mistake of fact, but that's fine. And the court says, now, they can also now stop you even if they say, wait a minute, you're not allowed to wear, glasses after 7 o'clock p.m. That's what I thought. If that's a reasonable interpretation of the law, then the court says that's not an unreasonable seizure under the Fourth Amendment. The court was really clear, though, and said it's an objective determination, not whether an officer can come in with, very specious reasons and say, I thought. The court says it's an objective interpretation, and that's going to invite a lot of litigation in years to come over whether the officer's misunderstanding of the law was objectively reasonable or not, and therefore whether the Fourth Amendment protection covers the defendant when the officer has seized them under the Fourth Amendment and it had no legal authority to do so.
Thank you so much. Another bucket of significant cases at the court this term involved issues related to politics and voting. And we have with us Jerry Hebert, who's both as a litigator and as a writer, known as one of the nation's foremost authorities. He is the director of the Campaign Legal Center. Among the many other jobs he had was as the acting head of the voting section of the Civil Rights Division of the Department of Justice. So, Jerry?
Thank you. Thank you, Tom. And thank you to ACS for sponsoring this event. Great organization. And I'm thrilled to be here. I have to say that if you told me at the beginning of the term that we would see decisions upholding civil rights plaintiffs' claims in the Alabama redistricting case, that we would find Chief Justice John Roberts rejecting a First Amendment challenge to judicial candidates soliciting contributions and getting contributions and applying strict scrutiny, but still upholding the campaign finance law. And if you told me that RBG, which stands for Ruth Bader Ginsburg, but I consider it to be right, bold, and great, would write a decision in the Arizona case upholding the right of the commission to do the power of redistricting to curb partisan gerrymandering, I probably would have looked at you with the same degree of lack of credulity that I would have 20 years ago if you told me that 20 years from now we'll have a black president, that all Americans who want affordable health care will have access to it, and the states will have to recognize same-sex marriages. It's just really amazing. So my talk is, I think, a little bit about hopefulness. In contrast, I saw on the way in here that Rick Perry is speaking here tomorrow on the cycle of hopelessness, which I take it is not a commentary about his campaign. All right, so let's begin with Alabama. Alabama redistricting was drawn by the Republicans when they took over the legislature, and what they decided to do was to take all of the majority black districts and to say that when we draw these districts, we are going to draw them the same number, and we're going to maintain the black percentages in each one. And we're going to do that because we want to avoid retrogression under Section 5 of the Voting Rights Act. Section 5 was in effect at that time. This is pre-Shelby County. So the plaintiffs challenged this on a number of different grounds, and I have to say I was not involved in the case except assisting with the advocates in the Supreme Court, but I have to say that Justice Breyer went out of his way to give a very liberal reading to the pleadings below so as to incorporate what he considered to be their true claims of racial gerrymandering some of the districts and overly relying on race, so much so that he actually had an appendix to his opinion where he listed all the pleadings where you could find support for the fact that the plaintiffs really litigated the case in the way that he said they did, and Justice Scalia took him to great task in the dissent for having done so. So again, this was a case where the plaintiffs were claiming that Alabama should not have applied race in the predominant way that they did, that they overly relied on it, that they misinterpreted Section 5 of the Voting Rights Act, which does not require you, they said, to maintain the same racial percentages. This is the first time the Civil Rights Voting Rights Bar has despised the Shaw v. Reno line of cases since 1993, and yet this was one of the first cases where they actually utilized that weapon to bring the challenge. And they had to show that race predominated in the creation of these districts over traditional redistricting principles, non-racial principles. So there are several takeaways because the Supreme Court said these appear to be racial gerrymanders and actually sent it back to the lower court, but had some very strong language in Justice Breyer's opinion for why they essentially believed that many of these districts violated this Shaw v. Reno doctrine. One takeaway is that you have to have plaintiffs who actually live in the districts that you're challenging. And it was not clear, even at the Supreme Court level, whether the plaintiffs really had met that particular goal. They said that we have, one of the groups was a member organization, and they said we have members in all the districts, in nearly all the districts. Well, as Justice Scalia points out in dissent, nearly all isn't all, so maybe they don't have some, and some of the districts are challenging. But so on remand, they have to cure that effect. The big takeaway from the case, though, is that it really is going to go forward and impact a number of other cases that are pending now. Cases out of Texas and Virginia, for example, that also allege discriminatory intent. And in those cases, again, before Alabama was decided, the state had come in both cases to say, well, to avoid retrogression under Section 5 of the Voting Rights Act, we had to maintain these districts at a certain percentage. And the Supreme Court has now rejected that and said, no, the test is really whether or not the district continues to provide African American voters with a realistic opportunity to elect a candidate of their choice. And it doesn't require this rigid calculation or adherence to a particular percentage. The cases that are percolating out there now, there are 3 redistricting cases involving race from Texas, in addition to Alabama, Virginia, and North Carolina. And I think what you're going to see, because this case has really made it harder to rely on the Voting Rights Act to achieve partisan gerrymanders, which is really, I think, what ultimately people think is a safe harbor. So when you deliberately pack minority voters into a district because they vote overwhelmingly Democratic, are you packing them into that district as a partisan gerrymander, or are you packing them into that district as a racial gerrymander? We'll see. This issue was particularly important post-Shelby because now, in order to get preclearance, you can bring people, you can bail them in for preclearance by showing that they engaged in racially discriminatory intent that violated the Constitution. So in many cases now, whether they're Texas photo ID, North Carolina case, big case pending, redistricting in Texas, redistricting in Virginia, everybody is trying to seek 3C relief and get preclearance brought back in. So we'll see. The one thing that's interesting about Justice Kennedy joining the opinion is that this is a case that has that mixed motive of partisan intent. You may remember that he was the 9th justice in Veith versus Jubilaire, the big partisan gerrymandering case from the mid-2000s, where 4 justices said that partisan gerrymandering wasn't justiciable. 4 of them said that it was justiciable, and they had various tests. He couldn't agree with any of those tests, but agreed with that it was still justiciable. Well, the problem is that no case has justiced it yet. We're still waiting for the Supreme Court to come up with a theory, and so since they haven't done so, maybe these are cases that kind of get at the partisan gerrymandering without the court actually having to come up with a constitutional theory. The other cases, a bucket of cases, Williams versus Williams-Yulee, well, that was the Florida case where I mentioned the judge challenged on First Amendment grounds the right to solicit contributions to their campaign. And the Chief Justice, for the first time in a campaign finance case that he's been on, and he's been on 7 of them, he has struck down campaign finance laws. This one he actually upholds the judicial restriction. And he does so because it's clear that public confidence in the judiciary really weighs heavily on the Chief Justice's mind. Judges are different, he says. They're not politicians. They're not like politicians. States can regulate judicial elections differently than political ones. Politicians are expected to be responsive to their preferences of their supporters. Judges are supposed to be even-handed, balls and strikes. Remember that from his confirmation hearings. So, but many of us in the campaign finance field wonder, well, shouldn't we equally care about public confidence in our elected officials in our democracy as much as we care about having confidence in the judiciary? I mean, after all, democracy only works, I think, when the people have faith in those who govern them as well as those who decide cases in court. The big takeaway, be aware there's a Ninth Circuit case that's pending en banc. It's being briefed now. It's out of Arizona. Arizona seems to dominate the stage these days in many ways. Here are canons of ethics from Arizona that prohibit judicial candidates from making speeches on behalf of political organizations or candidates, publicly endorsing political candidates. It also involves the Williams-Yulee contribution issue. The case was stayed for the last year pending the Williams-Yulee case. The last case, the Arizona Commission case, which was mentioned earlier by Bill, the interesting part about that case is it could have had disastrous consequences. Everybody looked at the case as if to say, if this case goes down, we're going to lose independent commissions to do redistricting. This was a challenge by the Arizona legislature that claimed under the Elections Clause that it had the authority to do redistricting, and it got taken away from them. Well, because it did get taken away from them, they had standing to challenge it. But they lost the case, but it had huge consequences because there are numerous time, place, and manner regulations and rules that have been adopted, not just with respect to independent commissions, constitutional amendments. Secretary of State issues a regulation. That could be something that was done without the legislature's authorization. All of these things, I think the Brennan Center actually had about 87 examples in a publication and maybe one of their briefs that talked about that. Again, Ruth Bader Ginsburg, great decision for democracy. She says the Elections Clause is in line with the fundamental premise that all political power flows from the people. Haven't heard that from the Supreme Court in quite a long time. So again, I think, voters in Arizona, she says, turn to curb partisan gerrymandering, where the court noted involves an inherent conflict of interest. When politicians choose voters, that's not democracy. It's supposed to work the other way around. And so I think seeing language like that from the Supreme Court is very, very encouraging. I think it'll give encouragement to reformers and funders to go out into some other states now and seek some reforms. The last point I want to make is that there were 3 stay issues in the Supreme Court at the very beginning of the term. Wisconsin, photo ID, Texas photo ID, and North Carolina. In each case, the Supreme Court stepped in. In one case, they granted a stay in Wisconsin to a 7th Circuit's decision that had put into place the photo ID law that had previously been enjoined. This is just prior to the election. In Texas, there had been an injunction issued by a trial judge just prior to the election in 2013. The 5th Circuit stayed it. The Supreme Court refused to vacate the stay. North Carolina, the plaintiffs had challenged some laws that were about to take effect. They lost a preliminary injunction in the lower court. They got one out of the 4th Circuit, and the Supreme Court stepped in and vacated that stay. So what's the takeaway for 2016? The takeaway is this, that election officials making last-minute changes are going to be vulnerable to an injunction. Litigants will have to go out and get injunctions early, but not be premature in their litigation to set up the status quo, because it's pretty clear that the Supreme Court has decided that instead of the usual multi-factor test in deciding whether a stay is going to be granted, it's really just one factor. And that factor is, Are you changing something close to the election? And if the answer is yes, and I suspect next year we'll see a lot of litigation on last minute, if you're changing something, the status quo prior to the election, the Supreme Court is likely to step in, and probably the lower courts will too. Thank you.
Thanks so much. I'm so grateful to each of the panelists for being not just so thorough, but also so concise. We had made a commitment so that we could finish up here about 20 minutes early so that we could take some questions from folks in the audience. And I'm not sure if we have a standby microphone or not. Yes, here it is. So we'll start with the press, if you don't mind, if folks want to ask a question.
Hi, Kenneth Jost, Supreme Court Yearbook and Joestone Justice. All of the headlines of the wrap-ups, including mine and everybody else's, have stressed the court's liberal tilt during the past term, and I wonder if any of you have comments on the extent to which that is accurate or inaccurate, misleading, or probative.
Anybody want to say something? I'll give you my 2 cents, Ken. So the numbers are as follows, that if you were to take the 26 cases that have some kind of ideological valence and were close, either 6-3 or 5-4, the left wins 19 of them, and 8 of the Big Ten. But we know these people are the same folks we've had in previous years, and so there's not some intuitive reason to think that suddenly they ended up being substantially more liberal. I think one of 2 things, and probably a combination of them, is happening. One is the accident of cases. Cases get on the docket. That's just how it is. And if you look at next term and you think about things like public union financing, which is going to be an extremely fraught issue, affirmative action, and in all likelihood abortion as well, you would expect to see a different set of results. And then the second thing is that it's possible that while the court has been moving to the right for 20 years, it's hitting the wall on some of these doctrines. And so what we actually think of as a liberal result is just a not further conservative result. You can think of, right, it's just like we like breathe a sigh of relief, but it's not actually, with the exception of same-sex marriage, a move to the left at all. A conservative court didn't strike down the Affordable Care Act. It didn't limit the use of race in fair housing in disparate impact claims when that was an accepted means of litigating those cases for 25 years. And so I think that we'll learn a lot more in the next year or so about whether the move to the right of the court continues or it has run out of gas to some extent.
If I could just compliment what you're saying, I want to resist the question because that's the way it's been put in the press. I think that's wrong. I think what happened this term, which is maybe fairly reflective, is the modern regulatory state got a big shot in the arm. I think that's the thing that puts together Obergefell and King. King is, what I think is notable, but this is all Harton Sachs legal process. The Chief Justice's opinion says, look, there's this great plan that Congress has put afoot. Are we going to mess it up based upon a scrivener's error? And the Chief Justice says no. And I think Obergefell can be read along the same lines. You know, family law is the government sets up a mechanism for people to make life plans for themselves, and you can't arbitrarily exclude lesbian and gay people. That might also explain some of the criminal cases, which unfortunately are a different kind of regulatory state, and maybe the Confederate license plate case as well. So I don't care how you characterize it. I think the modern regulatory state is here to stay, and even extremely conservative justices are now internalizing that in the way that they think about the Supreme Court doctrine.
I have a 5-second comment to put this question in context, and it quotes Stephen Colbert, who says that, just think, gay Americans achieved full constitutional personhood just 5 years after corporations did.
Other questions?
I'm Greg Storr with Bloomberg. A bit of a follow-up to that question is, why did the court take some of these cases? In particular, why did they take the healthcare case, and why did they take the Texas housing discrimination case?
I mean, I think for King v. Burwell, I mean, there was a split. I mean, the Fourth Circuit had gone one way and the D.C. Circuit had gone another. It was an incredibly momentous question that was going to affect billions of dollars and millions of lives. And so I think it satisfied multiple criteria for certiorari. On the Fair Housing Act, same thing. I mean, it had been a disputed question for a long time. They'd settled it under the ADA and Smith, but obviously Scalia there had crossed the side of the aisle and laid the groundwork for then what they ended up saying in the Fair Housing Act. I think it was surprising to see Justice Kennedy came out the way that he did, but I didn't think it was surprising that the court took the case, and I don't think most court watchers were surprised. I mean, they had taken it twice, and both times it had been scuttled, and they didn't get a chance to answer the question. So I don't think anyone was surprised when they granted the Texas case. Are there surprising grants for next term? I was surprised by the one person, one vote grant. I think, question for the panel, that one is much harder for me to explain than either King or the Texas housing case. I mean, Jerry has a view on why they granted it. I'm not sure.
Yeah, I mean, here's a...
I can explain what the case is,
Sure.
and then explain.
So there was a case brought in Texas challenging the right of the state of Texas when they enacted their Senate redistricting plan by using total population to accomplish the one person, one vote, equal population requirement in each district. The plaintiffs claimed that they should have used a subset of the population because representation is all about voters. It's not clear whether they want to use registered voters instead, or whether they want to use citizen voting age population, or actually the people who turn out. All of those have very pernicious consequences for minority voters. Now, this has been a pretty well-settled area of the law for decades. Since the 1960s, that total population pretty much is the base that is used to redistrict. And it's also the number that's used to allocate congressional seats among the states. We allocate seats, congressional seats, based on total population. So it's kind of a well-settled area. It really is questionable. There's only 2 states that use something less than total population. That would be Kansas and Hawaii, who both take out temporary residents. So military people who are temporarily stationed in the state, they take those out of the total census population, and then they redraw the lines, and that's been upheld by the Supreme Court decades ago. So the Supreme Court has taken 3 cases for the next term in the area of redistricting. I mean, it's astonishing. They've got the one person, one vote case I just mentioned. There's another case out of Arizona. They uphold the Arizona Commission's right to be a commission to do redistricting, and then they take a case the next day that says, we're going to review whether a challenge to whether or not the plan you drew violated the one person, one vote rule, whether you properly relied on the Voting Rights Act, whether you allowed deviations within a 10% range. I mean, so it's got a whole host of issues. And then a third case out of Maryland, where the plaintiffs brought a case, a partisan gerrymandering case. The district judge threw it out, refused to convene a 3-judge court, and the case is now up to the Supreme Court about whether or not that failure to convene a 3-judge court in that redistricting case makes sense and is legal. So it reminds me of Shaw v. Reno in a way era, because everybody drew plans in 1991 and 1992 thinking we had to draw majority minority districts no matter what they looked like, and we had to do it. And then when they all did it, the Supreme Court came down with a decision in '93 that said, aha, appearances matter when it comes to redistricting. Don't draw these silly-looking majority-minority districts, or you'll have to meet strict scrutiny. And litigation boomed for redistricting lawyers, which is good for me, but not for democracy necessarily.
Oh, sorry.
I'm not the press. Am I allowed to
Yes.
ask a question? Thank you very much. Elaine Middleman, I think everyone acknowledges that Congress really isn't doing its thing. And so when the justices say, well, if this is a problem, Congress can fix it, that really is just a laugh line for the Solicitor General. So I don't know, should you just operate as though there is no way to fix a law and that just hope for the best with what exists now? Or what, when you have one branch of government that's just not working, how should the Supreme Court react to that?
So yes, from the perspective of the justices and their job, and they say, well, we have statutory stare decisis. We're not going to overrule our interpretation of this case, or they have a very high bar for finding an absurd result. And they say, go across the street. Do you think that they really believe it? Do you think that Congress pays attention when they say it?
Well, In the case of Shelby County, the Congress isn't paying much attention because they have had a Voting Rights Act amendment pending there since almost since Shelby came down, and they haven't even given it a hearing in a committee. So I don't know that the Congress certainly doesn't seem to take it very seriously.
I have talked to some of the justices about this. I just did an article in Texas on the collapse of statutory overrides since the Clinton impeachment, actually, not just recently. And none of the justices was aware. And I think they're still kind of in denial about that. Sure, they realize that Congress is kind of dysfunctional now. And I believe that did get some laughs in the various Affordable Care Act oral arguments. But I don't think they've really internalized, how vast is the sort of underperformance of Congress. One thing I would add about that, again, resisting your question just a little bit, I think the big winner when Congress is dysfunctional is the executive branch. And so we might have seen that in King versus Burwell, that puts a smidgen more pressure on the court not to break the statute, realizing that Congress is not going to fix it for them.
I was just wondering if anybody can comment on whether the term tells us anything enduring about statutory construction and the use of legislative history in it.
Yes. No, I can't say I've read every single case. I think there were 76. I've read the main ones. This was not a big term for legislative history. In a lot of the big cases, statutory cases like King versus Burwell, now that was a complicated statute, and Chief Justice Roberts says it's inartful because it didn't go through the committee process, says the Chief Justice, I believe accurately. You saw very little reliance even on committee reports. Probably the high point was Justice Kennedy's opinion in the Title VIII case, where he relied on committee reports, and I think Senator Kennedy as well, in ruling that there was a disparate impact claim for relief under Title VIII. So what we now have, at least this term, if it's representative, is that, and this is what I was going to say about King and Burwell, the Chief Justice seems to be saying in King and Burwell that even if that language is established, exchanges established by the state, even if you think that's unambiguous or clear, and he cavils about that a little bit, it's made ambiguous by the whole act and the statutory context. The only other reason I can think of that said that was Justice Scalia's opinion in Rivermaker several terms ago. So this is now a court where whatever you have as the appropriate text, when we say look at context, what they mean is not legislative history. And I'm not just talking about Scalia and Thomas, I'm talking about the Chief Justice, Justice Sotomayor, Justice Ginsburg. They are not looking at legislative history, or at least, I'll take that back. They are looking at it, but they are not citing it anymore. And that is a very important distinction, okay? And this term is, I think, a nadir in my lifetime for the Supreme Court's reliance in big cases and small on legislative history to interpret statutes. It's very much dominated by the whole act and by the judicially created canons of statutory construction. And so, and I might add, perhaps gratuitously, by dictionaries. This is a court that and this is bizarre, that statutory language, the Federalist Papers have been explained as by Justice Scalia. I cite them, he says, to tell me what the Constitution means, the words and the structure of the Constitution. When they get similar questions at statutes, the current Supreme Court does not look at legislative history like the Federalist Papers. Instead, it looks at dictionaries, which are an impoverished source of meaning. But no, because they don't look at clusters of words, they don't look at policy context, they don't look at what the democratic process is focused on. It's really the world of bizarro Superman that the Supreme Court has now entered us into, when the respected deliberations of our elected representatives are ignored in the published decisions, and dictionaries are the source of authority almost universally. So there.
One footnote. I'm not sure that the term, because of the mix of cases, tells us a lot about legislative history or maybe even the canons of construction. But I do think, I used to believe that statutory stare decisis was not a whole lot more than lip service. And that is certainly still true of Justice Thomas. But I think for the rest of them, it has come to hold, I think, more sway. I mean, they granted Harris v. Quinn and the Halliburton case last term, and both people said, a lot of people said they're going after Abood, they're going after Basic v. Levinson, and they didn't in either case. And now they've granted Friedrichs, and everyone will say the same thing. And maybe that's right. Certainly several years ago, I would have said that that's the easy explanation. They've granted Fisher, so people will say they're going after the Michigan affirmative action cases. But I'm not so sure. I mean, the bankruptcy case this term on Brulot, a precedent that none of them seem to think is correct, and they didn't overturn it. And so I actually think that for a majority of the court, statutory stare decisis has more hold right now than I think it did maybe 10 or 15 years ago.
All right, we have time for one more question.
Yes, sir. My name is Cam Hebert. I'm with the Pakistani Spectator, and I attended event yesterday on the same topic at the Heritage Foundation, and there were a lot of resentment, even anger. So,
yes.
Isn't that the objective indication that court has moved to the left? Thanks.
So does the fact that there were tears at the Heritage Foundation, beyond bringing a smile to one's face, tell you, no, it's not true. It's a wonderful organization. Does it tell you anything more? The reaction from the right, does it portend that they believe that something more is afoot? Nadine?
Well, there have been a couple comments in response to that first question about is the court moving to the left, that just that the liberal justices have been more disciplined and have been working better as a team. So maybe there's frustration that the so-called conservative justices are more concerned with their infighting and standing up for their own idiosyncratic views of conservatism and judicial review. So there may be some sense of frustration that they're not marshaling their resources as effectively as the more liberal justices are.
Even if they are moving more to the left, they're not moving that way with respect to criminal justice. I think most people would agree that their opinions remain pretty conservative and across party lines in some of the cases. The justices did not divide in the traditional way in the criminal justice context. So it's not across the board, even if it is the case in the civil and civil rights cases.
Let me just add some rank speculation, and others who on the panel who know a lot more about Supreme Court justices than I do, but I think that what has happened, and I hesitate to reveal this top secret because I'm afraid the Heritage Foundation will follow my advice. That would be interesting, wouldn't it? Which is that I think that the conservative litigants have pushed the envelope so far to the right that Justice Kennedy is uncomfortable going there. And so I think he's oftentimes now, as we saw in the Alabama case and as we saw in the Arizona Commission case, I think he's just not willing to go out that far. And I think that may account for some of this. Instead of the court becoming more liberal, I think it's more, and it all comes down to Anthony Kennedy these days. So that's my rank speculation.
The atmosphere among the conservatives seemed as fractious to me as I have seen it probably in the last 20 years. I mean, you find Justices Scalia and Alito sniping at each other in the Confrontation Clause case. You won't say the name of Justice Alito who was writing the opinion. You see Justices Kennedy and Thomas in the solitary confinement case going at it. I mean, 10 years ago, Justice Thomas doesn't write that concurrence to take a shot at Justice Kennedy. He just lets it sit. And then you see the Chief Justice and Justice Scalia obviously going at it in King v. Burwell. I mean, I don't know whether the court is moving to the left or the right. Tom's numbers are much better on that than I am. But the conservative wing of the court certainly does not seem to be getting along very well right now.
Here's another case, 2 minutes.
No. Because our good friends at C-SPAN are here, we really have to be faithful to our time. It is exactly 2 o'clock, so we have done that. Please join me in thanking both ACS and our panelists. Thank you so much.